Welcome, everyone. I'm Lori Nelson. I'm the Director of Alumni Relations at the University of Utah S.J. Quinney College of Law, and I'm pleased to have you joining us today. We're very fortunate to have our panelists today. We're going to be hearing from Matt Driggs, who's a partner at the Advocates, and from John Snow, who is a partner at Parsons Behle, as well as the chairman of the Utah Supreme Court's Ethics Committee. We're going to be hearing about some rules regarding lawyer advertising and communication. And it's important to know that under the Utah State Bar's CLE, well, the Supreme Court CLE rules, we're only going to be submitting the names to the bar for CLE credit for those people that stay the entire hour. That's a requirement of the bar. So we will be submitting those names and we will be forwarding to you the CLE certificate at the conclusion of this meeting, probably next Monday, for those people that did stay for the whole hour. If you have a question, please feel free to ask a question. Use the Q&A feature, not the chat feature, and we'll be moderating those questions. We will probably answer the questions at the conclusion of the two panelists' presentations, but please add your questions as you go along using the Q&A feature. And then we will get to those questions, but to start with, let's throw it over to Matt. Matt, can you kick us off, please?
You bet. Good afternoon, everyone. Thanks for joining us. I was thinking about this, and 2020 was a year of a lot of shakeups, and I was thinking back to the summer. I'm sitting at my computer, and it felt to me like I kept getting rule change after rule change, and I kept seeing all these things happening with the Supreme Court rule changes. Seemed like a lot was going on, and in August, there were two rule changes that really jumped out at me and have a big impact on my practice. I do a lot of advertising, and so these two rules were big. The first one was Standing Order number 15, which in conjunction with Rule 5.4, I created this concept of a sandbox, and that was a big change. And then the changes to Rule 7.1 through 7.5 advertising rules. They were big, and I didn't understand how they integrated with each other. And so when I was talking to Lori a few months ago, she asked me what topics might be relevant, and I thought, God, this was a good one for me, and I've enjoyed preparing for this. And I also want to do a shout out to John Snow, who's joining me here. I appreciate his willingness. I called him thinking, okay, you know better than anybody, and he agreed to join us for this seminar. So thank you. I'm going to give a little bit of a background, and then I'm going to turn the time over for a couple minutes to have John give a few minutes of a background. Then it'll come back to me. We'll spend maybe 10, 15 minutes or so talking about Rule 5.4 and the sandbox stuff. And then John will take the second half of the conversation talking about 7.1 and the changes that happened with advertising rules. So that's where we'll go. And then we'll be happy to answer questions, give examples, do whatever, and go from there. So by way of background for me, I graduated almost 30 years ago from the U. I was with Lori. She was one of my classmates. And it's crazy that it's been that long. And at the time, I laughed because I didn't really have that many job opportunities. So I hung up my shingle and started a solo practice from scratch. Did that for several years. Then got a place downtown in Salt Lake City. My first attorney hire was Ken Bills, and my second was Steve Day, and we created Driggs, Bills, and Day, and ran that way for several years, primarily focusing on personal injury. That's our firm. And then about 12 years ago, we came up with the brand name of the Advocates, and so I have been involved with advertising and whatnot for injury cases for the past 12 years as the Advocates. And it's been a really fun journey for me. We have actually grown quite a bit over the years. We now have offices in 6 states. There are 35 lawyers practicing at our firm, and these rules are very relevant to us, and it's complicated because every state has different rules. And I guess I really got involved with these specific rules, 7.1, about 4 years ago when I ran into some issues with the bar regarding radio advertising and using radio talent to do spots for me on the radio. And so we had some issues. I remember going up to an American Bar Association annual convention, and they were having a big meeting on Rule 7.1 through 7.5, the advertising rules. And so I went there to speak at that event, at that convention. And I remember being in this room. There was the panel, the committee from the American Bar Association. But then the room had maybe 100 to 150 lawyers there from all across the country. And at the time the question was posed, what do we do with these rules, these advertising rules and the model rules? And when it was posed, do we make them stricter, more clear, try to define them better, or do we just go to, more simplified rules? It was an overwhelming, it was every single person in the room voted to move towards a simplified version of the rules. And I wanted to give a big shout out to all those individuals over the last several years who have made that happen in Utah. I think we are the people at the front lines moving this issue forward. And it certainly, at least from my involvement with the American Bar Association, was what everyone has wanted to do. So for all the bar members, the Supreme Court, and those individuals, thank you for moving that forward. So I'm excited to talk about this. I'll let John take over for a few minutes and introduce himself, and then we'll come back to the actual rules themselves.
Well, my name is John Snow. I'm with Parsons Behle, and I don't have nearly as interesting background as you do, Matt. So I won't need that much time. But when you said you graduated 30 years ago, it made me think how long it's been. And I've been practicing longer than you have. I graduated in 73. And that made me feel really old. And I don't feel old. And I enjoy practicing. So I don't even think about retirement. But I did graduate in 1973, and I've worked with firms ever since. I've never hung out a shingle. I've never thought about being on my own. I've always had somebody else to protect my administrative interest. And when these rules were changed on advertising, I'm going to be joking when I say this, since people don't know me, they may not know that this is a joke. I said to myself, I don't advertise. I don't have to worry about these rules. And a lot of lawyers think that. And the fact of the matter is, each and every lawyer advertises if they have a website, if they have LinkedIn, if they make donations to charities and have their name put on the board. There is some form of advertising. And although a lot of lawyers like yourself you said you're very involved in advertising, the fact of the matter is we're all involved in advertising. And we all need to be aware of what Rule 7.1 and what the other provisions in this rule provided. But let me just say I've enjoyed the opportunity to speak with you and get to know you. And it's nice seeing Lori again. So I'm done with my introduction of myself. Other than I'm a very nice person, I don't think that was mentioned anywhere. Oh, I did have one correction. Since I'm talking about truthfulness, it's not the Supreme Court rules of ethics opinions. It's the state bar, not to be confused. And I should have made sure that was correct in the first place. And you said you called and asked somebody who may be knowledgeable, and that's underline may. I don't want to be making the suggestion or implication by not correcting you that I am not all that knowledgeable on everything on rules. But I happen to know these. So anyway, okay, with those corrections. Thank you.
You bet. Thanks again for joining us. Yeah, it's true. As I was thinking through these rules, they're complicated, and we'll have some time at the end to go through some examples. And yeah, being an expert is complicated for sure. So let me talk about, for the next few minutes, this Supreme Court Standing Order number 15 that was issued or signed back in August. And it's about I think it's an 18-page document that outlines this new program that we refer to as the Sandbox. So by way of background, the Supreme Court has been worried for years, or has been trying to figure out ways to improve access to the legal justice system. There was one study noted in the order that showed that in Utah, for the low-income population, quote, that there was an unmet legal needs at about, or that stood at 82%. So there's a need for these legal services, and the Supreme Court wants to address that and help people. And so they've been working towards that. And one of the things that became very clear is that lawyers were not going to be the ones to provide these services. At least that's how it seemed. One of the quotes that I thought was interesting in the order said, "What has become clear during this time is that real change in Utah's access to legal service requires recognition that we will never volunteer ourselves across the access to justice divide. What is needed is market-based, far-reaching reform focused on opening up the legal markets to new providers, business models, and service options." And I thought that was interesting because, at least for myself, I mean, we're all in this for a profit, and I think that the Supreme Court recognized the need for opening up the legal system to others, non-lawyers. So that's the background of this order. And so what they ended up doing is they created what is called the Innovation Office. And this Innovation Office is tasked with creating these non-traditional legal services that might be outside of, the ethics rules and some of the bar rules. And again, that's what we've referred to as a sandbox. I think you think of a sandbox with a bunch of kids playing in it. That was the goal, is that lawyers and non-lawyers could come up with innovative ideas on ways to provide legal services in Utah, different than we've been doing it in the past. So hopefully there are novel approaches. Basically, if someone has an idea, whether a lawyer or non-lawyer, they can present an application to this Innovation Office to try and move forward with ideas outside the scope of the ethics rules for lawyers. So it is a 2-year program, or this order lasts 2 years, and then it is going to end. So this isn't going to continue forever unless they adopt it into a permanent situation, but it's really only a 2-year test program. The office itself, this innovative office, is made up of one chairperson. That currently, I believe it's John Lund. Then there's a vice chair, and then there's 9 other individuals on that committee. And the objective, as stated in the order, the objective, there's a singular objective. It is to ensure customers have access to a well-developed, high-quality, innovative, affordable, and competitive market for legal services. So that is what they are tasked to do. This Innovation Office is try and find those, or encourage others to come together to find innovative ways to provide these legal services. So what ended up tripping me up is that there is a section in the order. It's section 3.31 of the order. And when it was originally released on August 14th, to me, it basically read, this section allows almost for a free-for-all with sharing fees with non-lawyers. It basically allowed it to non-lawyers to share fees with anybody, or lawyers to share fees with non-lawyers. And it was, you could interpret it that way. And I think a lot of people in my area of practice kind of potentially went crazy with that, going, oh, I can pay people for cases and do a lot of things. Within 2 weeks, they reversed that and they made these little changes. So on the 31st of August, which is the current order, that was changed so that it is no longer available to just fee split with anybody. So, I mean, at the time, I'm looking at all of these changes coming about, and I'm going, advertising now is way easier, and I can fee split and everything, and it all got jumbled together in my mind. As I have kind of worked through some of the issues, what I have come to understand is that there is a big distinction between the changes that happen to the advertising rules, that's the rule 7.1 through 5, as compared to this rule 5.4 of sharing fees and share fee splitting with non-lawyers. So the big distinction, like I said, is that 5.4 rule is about money. It's about, if you're going to pay somebody, look to rule 5.4 when you're thinking of the ethics. If you are going to disseminate information, if you're communicating about your firm, then you think 7.1. Those are the two things. So, you know, this order and this innovative committee, if you're going to be paying a non-lawyer for referrals, you must go through, this is how I read it, you must go through the innovative office and get approval for that if it's going to be fee splitting with non-lawyers or paying for referrals. So if you look at rule 5.4 and you look at the comments, comment number 3, I'm just going to read it. It says, paragraph C permits individual lawyers or law firms to pay for client referrals, comma, to share fees with non-lawyers, comma, or allow third-party retention. So hiring somebody else to get cases for it. In each of these instances, the financial arrangement must be reasonable, comma, authorized and required under Supreme Court Standing Order number 15. That's what I've been talking about. And disclosed in writing to clients before engagement and before fees are shared. So let me give just a couple quick examples that might illustrate how I'm reading this rule. And we can talk about it if anybody has questions. But let's say that you do estate planning and you find this blogger out there that has a huge following. And you go to this blogger and say, I want to pay you to write blog posts for me. In one scenario, option 1, let's say, is I'm going to pay you $1,000 per blog post. That is appropriate. That's fine. As long as you comply with rule 7.1, that's dissemination of information. If you say to that same blogger who's a non-lawyer, I'm going to pay you $500 for every case that signs up. For every referral that you send my way, I'll give you $1,000. That is closer to fee splitting. And so that's going to likely be governed under this rule 5.4 rather than the 7.1 rules that John's going to be talking about. So I'll give you another quick example that maybe illustrates this, and then I've got one quick thing after that. But let's use the example of a criminal attorney, a defense attorney who hires somebody, an independent person, hires them to go stand outside of the jails and pass out brochures, cards, and try to drum up business for them. Now, if that person is an employee, under our current rules, that would be fine. They can go out there and drum up business and get whatever business they want. If that person, the non-lawyer, is out there and the lawyer tries to pay them per case, hey, I'm going to give you $500, or I'm going to do it that way, or share this fee, that's again going to probably be part of this Rule 5.4 issues and may not be allowable under our current issues unless you get approval from the innovative office. And there's an application that you can fill out, go through that process, and move in that direction. So keep that in mind. I think that was helpful for me to see the distinction. Again, if you're talking about money, paying the money, think 5.4. If you're thinking about what you're saying, think the Rule 7. I got to finish with one quick thing, and I'll turn it back to John. As part of this rule and the changes in this order, if you are going to pay someone for referrals, you must give notice to your clients in writing. That is a component of this rule. And the reason I bring that up is, and that being a big deal, is currently there is a House bill, I think it's House Bill 179, that is actually creating a private cause of action for individuals that did not get notice, that they can sue their lawyer for damages, attorney's fees, and everything if notice was not provided to them and they were acquired, or the case was acquired because of a paid referral. So that has not passed. I think it's in committee, but if you're going to be paying someone for referrals, number one, obviously go through this innovation office. If you're concerned about that, reach out to them for sure. And number two, give notice, give written notice to any client that that might retain you before they give you any money, or you could face some serious, some damages. So with that, I can take questions now on this part, or we can talk about Rule 7.1. I don't know if there are any, but I'll go, I'll turn it back to you, John, if you want to take it from there.
Okay, I'll do it. And then the amendments to 7.1 were announced in a publication that said the Supreme Court proposes significantly simplifying the lawyer advertising rules in the rules of professional conduct. And then it noted that under this proposal, current Rule 1.7, 7.2, 7.3, 7.4, and 7.5 would be repealed and replaced with the new Rule 7.1. And it noted that notably, this proposed rule would eliminate the prohibition against in-person solicitation found in 7.3. Though it sounds like it is a huge change, in fact, most of what 7.2, 7.3, 7.4, and 7.5 did was give a implementation aspect to 7.1. In fact, in Rule 7.5, which is firm names, actually refers to 7.1 and said you can use a firm name that doesn't otherwise violate 7.1. Solicitation and advertising were somewhat different, but even in the advertising rule of 7.2, it made reference to the fact that the advertisements must comply with the obligations under 7.1. Advertising or statements regarding fields of practice also were considered by the bar that in enforcement proceedings as being violated when people would give misstatements concerning their area of expertise or certification. And that has all been incorporated into Rule 7.1. However, the fact of the matter is 7.1A has not changed at all. It's the same 7.1A. The new aspect of 7.1 is that a lawyer shall not interact with a prospective client in a manner that involves coercion, duress, and harassment. And thank you for putting up, or I may have done that. Did I? on a screen share?
I did it.
Oh, you know what? We can take that down.
Okay.
That's not necessary. I'm going to go through it in any event and talk about this, what is actually included in the new 7.1. And first of all, the language of 7.1 is modified by, not modified, but explained by the comments. And the comments actually refer to aspects of the former rules regarding truthfulness. And the rule simply is a lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. So what does that include? Well, a communication is false or misleading if it contains a material misrepresentation of fact or law, that's a given, or omits a fact necessary to make the statement considered as a whole, not materially misleading. This is exactly parallel to our obligations of honesty and truthfulness contained in, among other rules, 4.1. 4.1 talks about what we can and can't say while representing a client, which is the same, or essentially the same, as what we can say about ourselves and our services under 7.1, which requires that it be truthful. For example, an example of not being truthful would be on your website putting down that you recovered judgment for $10 million or some extraordinary, or what would seem to be an extraordinary sum. But if you look up the case, you find out that, oh yes, he did get a judgment for $10 million, but it was a default judgment. It would be misleading to the general public because it would appear that you tried a case and really had a big result and had a successful result, when in reality, it was they defaulted, you got a judgment for that amount. Without naming names, that actually is on somebody's website. It was a lawyer I never heard of before, and I looked it up, and I happened to know us a little bit about the case by pure coincidence, and I knew it was a default judgment, but it was pure chance that I discovered that. But it was somewhat interesting, and the reason why I looked it up at all was sometimes you look up lawyers when you're dealing with them for the first time just to see who they are if you don't know them. But in this instance, this lawyer was talking like he had practiced for a bazillion years, and he didn't sound old enough to know, and he was making mistakes. So I looked him up, and he'd been practicing for a year and a half. And then I saw this $10 million judgment. That's really impressive. And then I realized what it was. Anyway,
John, can I just ask you a quick question on this?
You can do anything you want. You're in charge.
Oh, yay me. No. So would it be misleading for me to put up an advertisement that said something like, I'm the premier family law attorney, or I'm the premier female attorney, or I'm the premier grandma attorney, or something? I mean, is putting something on social media that says I'm the premier anything, is that misleading?
It can be. And the test for determining whether or not something is misleading when there's puffery involved, most of us lawyers will clearly know that premier, leading, voted best are not meaningful. But your unsophisticated consumer of legal services may not. And if it gives the impression that it is factually verifiable, that you are in fact the premier, the voted best, then it would be misleading. If it gives the appearance that it's factually verifiable and not, then it would be considered misleading. Do you remember, I don't know that Avo still is around or is still doing this, but I think it was Avo that was selling certifications, but I guess it was their own certification, that you were the best at some area of law if you paid them a fee. And then you would advertise best estate planning lawyer in all of Utah County, and you paid the fee, and it was sponsored by Avo. I think it was Avo. And that was clearly meant to be something that they wanted the public to believe was factually verifiable. And it's not, and it was misleading. And in fact, the committee on which I chair, the Utah Ethics Advisory Opinion Committee, we actually issued an opinion on that, talking about the certifications you get from ABVO, the Better Business Bureau. And in fact, in that opinion, we also went on and talked about where you have a consumer advocate that gets on the advertising and says, you know, I know these people and they're really wonderful lawyers. Well, to the average consumer, they may think this consumer advocate really knows the quality of legal services. And there was nothing that this advocate did that goes to or has any basis for his conclusion regarding the competency of the lawyers. But to the average listener, they would think that he's verifying their qualities as lawyers as opposed to paying the fee and getting verification. There was a little bit of background check done, but not anything of significance. And so we as a committee determined that was misleading and it was a violation of 7.1. It would be a violation of 7.1, but we also thought it was a violation of 7.2 for various reasons. But since we're only talking about 7.1, that's where we stuck. That's primarily what we were addressing in that opinion. The rule in the comments also talks about lawyer advertising, and those very specific rules regarding what you can and can't do have now been eliminated. The only issue is it truthful? And is it truthful in the abstract? When another aspect of that rule is where a lawyer will reveal what she or he has done in past cases, like recovered $375,000, covered $1 million, covered $6 million in a case. If that would indicate that you can provide the same results for the prospective client, and would lead the prospective client to believe that is factually verifiable, regardless of the underlying facts, then it could be deemed misleading. Whereas if it appears just prior successes in the abstract and a reasonable person would not believe that their own particular facts and underlying circumstances have a bearing on the outcome, then it could be misleading. And that's one of the reasons why you want to have a disclaimer that, you know, something like they do with securities, you know, past results do not predict future, past results do not predict future outcome. And then also the specialization rule has now been modified under this rule. And the comments note that you can use the term like I specialize in a field, but you can't suggest that you've been certified in the field by a certifying body, like the bankruptcy and domestic law bodies that do certifications. You can't suggest I'm certified in civil litigation when there is no body certified. But on the other hand, you can suggest that that is your area of specialization or focus under this rule if it's not misleading. Now, one aspect of the rule that is the new aspect of the rule, which is thou shalt not use a lawyer shall not interact with a prospective client in a manner that involves coercion, duress, and harassment. That is very subjective. But remember, the rules are very subjective in all respects. Well, not in most respects. And so what you're looking for is what would a reasonable lawyer do under the circumstances? So it's more of an objective test than it is subjective. It is not what you deem to be coercive, it's what it's going to look like after it's done. Showing up at the funeral and passing out business cards like not Robert Redford, I forgot his name. Gosh, how can you do this? I guess when you get older, you forget. But in the verdict, who was in the verdict? God, it doesn't matter. In the verdict, the lawyer would go to funerals and give his business. Oh, yeah, Paul Newman. Yeah, and give the business card to the widow or survivor, and suggest, you know, I'm sorry about the loss, and of course he would get run out a lot of the funerals they went to, but that was one of the ways he was generating business. I think most people would consider that perhaps, if not coercive, under duress, or harassing, it's certainly gross bad taste. And but in any event, it's when does it become a harassing? When does it become duress? When does it become coercion? Is going to be subjective and dependent on the circumstances. But one thing that is noted that in the comments is that there has to be a certain time allowed for reflection by the person that you're soliciting, so that if you go to the funeral and ask to represent the estate, that may not be the right time because there's not adequate time for reflection. But on the other hand, in your engagement letter, as a matter of fact, the client has the right to terminate the services at any time of their lawyer. So I'm not, well, you've got to be fair to the client. And I thought somewhere I was reading that somebody would ask the question or propose the question, would 50 emails be coercive or duress? I think you actually asked that question, Matt. I thought, I think one email from a lawyer soliciting work would be harassment, but perhaps one is sufficient. Maybe take two or three, but certainly capital banks advertisements to me, which are like every other day, I consider harassing. By the way, the rule also specifically talks about testimonials or endorsements can violate the rule if it's, and it can be if it's misleading. And, the endorsements, do you use endorsements at all, Matt? I can't remember. Yeah, I mean, the endorsement can be fine as long as it doesn't go to the point of suggesting that this person has evaluated your legal capabilities. Do you agree with that? Is that how you use them?
Well, so that's one of those interesting questions. So we just use them, it might be a radio personality that just says, oh yeah, where there was an issue with the bar is that one of the radio personalities made the comment, Matt's a good guy, or Matt's a good man. He's a good man. And they're like, wait a minute. Maybe that's true, maybe it's not. But they kind of took the position that that maybe you couldn't say that as an advertisement or as a testimonial. And so those are hard because you've got these people that are just talking that are going to make comments on the radio or whether it's an Instagram post or a blogger or who knows what, they're going to make these comments and they're going to say, oh, I've known Matt for 20 years. He's a good guy, or I like their firm. But I don't know, that it'll be an interesting position to take, that it's like, oh, you can't say that because you haven't verified their legal work. So I don't know, that has been a big issue for me, to be honest with you.
What about saying to a client, look, I'll waive the fee if you'll give me a positive endorsement on social media or on the website or something?
That certainly could be misleading if the person doesn't really believe it. I would think that. I mean, that's just that's an unthought out reaction to it. But if you're paying for the endorsement, it would strike me as misleading. But I haven't ever actually looked at at that. But that in that opinion that I was talking about, that the advisory opinion or the advisory committee issued actually dealt with the issue of the fact that the consumer advocate and the Better Business Bureau and AVO and some of these others are being paid to make the statement. And that was considered at least a factor in determining whether or not the endorsement or the testimonial was in fact something verifiable, and it was not based on it was not just based on paying the person to speak. So it's certainly a factor, in my view, which is conservative, because because I do represent lawyers in this area, and taking the conservative approach obviously is the safer approach, would be that could be a violation of Rule 7.1 or the old Rule 7.2. What do you think about that, Matt?
Yeah, my take on it is, I think if you're a known spokesperson, you're a radio personality, you're an influencer, you're a blogger, I think their consumer, the people they're talking to, know typically when it is an advertisement. They know that someone is paying for this advertisement. I think you step over the line, and this would be my take, and I'm sure there's a sliding scale, but from my perspective, if someone, a non-lawyer or someone that's promoting, giving a testimonial, says anything about your legal competency or anything that goes towards the legal competency without knowledge, that's where you're going to run over, you're going to have a tough time. If they say things like they've been practicing for 30 years, they have recovered this much, Matt's a good guy, those kind of things, I think those things are totally fine. That'd be my opinion. If they say something about a lawyer's competency without knowledge of that or experience with that, I think that is misleading and over the line. A problem.
Yeah, I think anything that is factually verifiable, you can say, or pretty much, unless the context of it makes it a misrepresentation. And I'm also licensed in Nevada, so I see some of these things in Nevada as well. But there was a lawyer that had a grizzly bear was like 90% of the page. This was some time ago when it was in the what was that thing called where you get phone numbers? I get a directory. The directory.
Yellow.
Now would be on his website. Had this giant grizzly bear, and in it said, "I can get you the same results." And the bar and he got into a dispute, and he changed that to "I can get you the same results" to something along the lines of let me help you get good results or satisfactory results. Made it less I can do this for you, because that obviously he couldn't guarantee that. And they were concerned about the aspect of guaranteeing a result. And that was under the same basic rules as contained in sub A of Rule 7.1. The comment says an advertisement that truthfully reports the lawyer's achievements on behalf of clients or former clients may be misleading if presented so as to lead the reasonable person to form an unjustified expectation that the same result could be obtained. And that's the standard. It's, disclaimers also take care of a lot of the issues with advertising or the potential for misrepresentation or misleading comments is with the appropriate disclaimer in the advertisement. So I may have gone a little longer than you wanted, and I apologize for that. I did. So I'm sorry.
Let me pose this question about some sort of things that could happen between the Sandbox Rule and the fee sharing and advertising. Can a lawyer and non-lawyer be engaged in a fee sharing arrangement and have it all completely fine, but then the non-lawyer does the advertising? Can that fall back onto the lawyer under 7.1?
Well, it can if the lawyer is participating in it under 7.1, but it also comes into play under 5.1 of the rules and 5.3 of the rules. 5.1 making it clear that a supervising lawyer is responsible for the conduct of managed lawyers in that lawyer's law firm if the person is a managing lawyer, has management responsibilities. 5.3 deals with where a lawyer has responsibilities for non-lawyers, including paralegals or legal assistants. But the rule has been interpreted to even be broader than that to apply to, for example, experts that have been engaged. And I would guess, I haven't made this comparison, so it's a little more than a guess, that the lawyer would still be responsible and is responsible for anybody still approved under 5.4.
Matt, is that?
And that is correct. Yeah, my reading of the standing order and the rule is that the lawyer is still responsible or still required to uphold all of the ethical rules that lawyers have to live by. So the tricky part for me is that on the one hand, I love the direction that Utah is going and that the bar rules and those things are moving towards. I always thought it was unfair that lawyers and their advertising for legal services were much more restrictive than some random lawyer. It's like, why are we as a bar, forcing lawyers into a position that's they're way worse off than a non-lawyer advertising company, that they could get away with advertising however they want. I mean, that was always hard. So I see the dilemma that you put out there. If you actually join up with a team of non-lawyers, again, the fallback is you better run it past this innovation office. If you're going to be paying for actual cases, not just advertising. I mean, when I do a radio spot, I pay them whether I get a case or not. If I hire some XYZ referral company and pay them for cases or for clients, I think that's where you're going to have a little bit more of a problem.
Well, but if you're fee sharing, the presumption is if the non-lawyer does the advertising and brings the work in, the presumption is the non-lawyer will get part of that fee. And then, so the incentive for the non-lawyer is to do pretty dramatic advertising. But the lawyer, all the lawyer is doing is the legal work and sharing the fee.
And so the answer, as I see it, is I think the governor or the Supreme Court wants to experiment with that. So you could get approval from the office, this innovation office, where they could go crazy with some weird advertising. And so they're not bound by those advertising. The only issue is it has to be approved. The application has to go through and be approved for that. And then there are not any restrictions, or the restrictions would be limited to what's outlined in the application. But without an application and going through that process, you can't just join up with a non-lawyer, have them advertise. I think that's just not going to happen. That's outside the rules.
So we have a question that says, what about a lawyer sharing part of his or her fee with a non-lawyer who, with the client's consent, interviews a client, records the necessary personal and financial information required for the lawyer to engage in the practice? So does the fee shared between the non-lawyer and the lawyer have to be roughly equivalent to what the fee would be if the lawyer had just done all the work themselves?
The fee has to be reasonable, period, under Rule 1.5. All fees have to be reasonable. The rules, Rule 1.5, where it talked about fee splitting, has been deleted, where it prohibited division of fees between lawyers. That has also been deleted. As far as the Sandbox Rule is concerned, Matt's going to have to address that because I don't know that specifically, but I would assume that it is implicit that you can share fees with the non-lawyer, but that has been certified under the rule.
Yeah, if you get approval from the committee to share share fees, it doesn't matter what the percentage is. You can do however much you want as long as you get permission. Where the issues are going to be coming up are you have companies like FindLaw, Avo, where you can pay for a list of referrals of form fills or chats that you can then reach out and you pay something for all of those referrals is, do you really have to go through the committee if you're just getting a bunch of form fills that you're reaching out to, as compared to you're working with a company to do that? I mean, we work with probably 10 different advertising companies currently that are all along that spectrum. So it's an interesting rule change for sure.
Does it make a difference if it's an hourly rate or a contingent fee? Under the new rules, can an attorney give an advisor or someone else a percentage of a contingency fee for advertising?
That's not a factor. Whether it's, if you're sharing the fee, you're sharing the fee, and it's going to be governed by this rule 5.4.
Okay.
And 5.3 does also refer to a lawyer associated with must make efforts to make sure that that person is complying with the lawyer's obligations, which is not to charge an unreasonable fee, one of which is not to charge an unreasonable fee under Rule 1.5.
Okay, so we have a question that says, at the outset, there was mention of being subject to these new rules if you make donations. What are some examples?
Oh, what I meant, I think they're referring to a statement. What I made was, I was thinking in terms of where you make a donation to a charity event, and the donors are all listed. And if you're a big enough donor, you're referred to as so-and-so premier donor or gold donor or platinum donor, and they give a little spiel about you under your name. And it might say something like, I loved your suggestion of premier grandmother estate plan or domestic lawyer. And making some type of statement that would be could be misleading. And it can happen. And it's part of the advertising. When I was talking about, where if you're LinkedIn or have a web page, and everybody does, you're advertising. And so this rule is still information about your services that you're permitting. And is it misleading? That was what I meant by that.
Okay.
I was, because it was the introduction, I didn't explain it. I just made a quick statement, and apparently I was misleading, and I apologize.
So avoid everything misleading. So let me sort of switch gears just a tiny bit, and let's talk about, I know in the past, there was this big deal about firm names and whether or not the firm names reflected the attorneys that were working there. How does that relate to sale of a law practice?
Under Rule 1.17 of the rules, which permits the sale of law firms, the rule itself doesn't say anything about how you can use the firm name, but there is a statement in Rule 1.7 that you can sell the goodwill. Goodwill is tied into the name. However, if you're using the name of the firm as a commodity, and that the sale is not a succession, but a new, totally unrelated law firm taking the name, that could be misleading by using the name. For example, if the Advocates were to sell that to me, and I have had no association with the firm, and nobody in that firm is still going to be there, it's me just taking a name, it could be misleading to the public who is familiar with the law firm, the Advocates. On the other hand, if I were to buy the firm, but everybody's going to stay the same, and there's actually a succession of the law firm without a break, then it wouldn't be misleading. Or if a not a junior associate, but an associate with the Advocates, a non-owner, wanted to take over the practice, they could do that because there is a succession. It's whether or not it's misleading to use the firm name. And that's where the issue has come up in recent days, where people are trying to buy firms and take over a firm, and whether or not it's actually misleading for a new set of lawyers to come in and use the firm name that really doesn't exist anymore. It's just a commodity. And that's where the debate is. Rule 1.17 clearly permits the sale of a firm, but it's still subject to the obligations of 7.1 regarding misleading use of the name. That makes sense?
Yeah.
How I read it as well is that anything to do with names and firm names and all that, there's no rules about that anymore. There's one rule, and it's misleading, false or misleading. So if you can somehow, through disclaimers like like John was just saying, things like that, as long as you can make sure it's not misleading, and like he was saying, it's a continuation of the company. And otherwise, it would be impossible for people. I'll just say Craig Swap, Siegfried and Jensen, those guys are in my industry. They could never sell it because their true asset is the name. And I can't imagine that is the direction that the bar is going, is to prohibit buyers and sellers of law firms, and they couldn't continue on. So I think it makes sense what John is saying. As long as the company itself is continuing, and there's a continuation, that's probably going to be okay, as long as you overcome any barriers of misrepresentation or misleading things with maybe disclaimers, things like that.
Yeah, and just
That's my take on it.
I agree. Disclaimers work. Disclaimers will work on that. If you're buying the name of the firm and have a disclaimer saying something along the lines of nobody formally, I'm not saying this would be a good advertising. You'd want somebody that does advertising to write it, but it would say something like, nobody previously associated with this firm are here. Everybody's gone. This is a brand new firm just using an old firm name. I mean, that's not how you would say it, obviously. There's probably a very clever way to do that. But if you make it known that it's not a successor, you might be able to, that may satisfy the issue of misleading.
And is the same true for a sole practitioner? They can sell their firm with a name as long as it's not misleading?
I don't know how you can do it. I mean, without a disclaimer.
Okay.
A solo practitioner has a unique issue. In fact, there's an opinion, or it's either a case opinion or a state ethics opinion that talks about solo practitioners selling their firm, and then somebody unrelated to the practitioner coming in and using the of counsel designation for a period of time for the transition, something along those lines. There's ways to do it by having the lawyer stay of counsel for a period of time, so it does have a certain amount of succession, or having associates with the firm if there were any. And when you say a solo practitioner, if they're truly a solo practitioner, it makes it more difficult. But if that lawyer is willing to allow the name to stay of counsel for a period of time, or have a disclaimer that so-and-so is now retired, you can do it. It's just, it's more difficult without a disclaimer.
So what about, like we've all engaged or entered into adhesion contracts where the fine print is so tiny nobody ever reads it. What about a disclaimer on a television ad that is so tiny and so fast that no one actually has time to read it, but it's there?
You mean like the pharmacy disclosures?
My approach, and I know we're getting to the end here, but my approach to this whole thing is be the kind of person you want to be. Be someone who errs on the side of protecting the consumer, following the rules as best you can. Do what you can to be an ethical lawyer. I mean, you don't want to push it so far. I mean, that's not the goal. I would say you do the best you can to be as ethical as you can. Look at it from a perspective of, are you really helping people and blessing people's lives? Move in that direction. So there's my 2 cents with all of this stuff is, do your best to make people's lives better and keep focused on that.
So is it allowed for a lawyer to pay his or her paralegal a contingency percentage in a case?
If they comply with the general rule that Matt was talking about.
Okay. Any final comments?
I thought Matt made a good point, is if you're trying not to be deceptive and just be a good person, you're probably going to end up complying with the rule 99% of the time anyway, because the technical issues have now been taken out. Now it's just a matter of good judgment of, am I being misleading? Is this misleading? And Matt's comment I thought was spot on.
Well, thank you very much.
Well,
You. I really appreciate your doing this for us. I know that this can be a very convoluted topic to talk about, because while I might objectively think that I am the premier grandma attorney, I don't know that that can necessarily be true of anyone besides me. So it's not really what I think. It's really what the general public would think, whether or not that's a misleading comment to make.
And if it's factually verifiable.
Yeah, well, then we know it isn't. So thank you both very, very much. I'm really grateful for all the work and time you put into this, and we'll get you to come in and present another one. Thanks to all of you who participated.
Thank you.
See you at our next webinar.